course, we're being joined in the program by a senior advocate of Nigeria, Mr. Afam Osigwe, joins us from Abuja studio. Let's see how he weighs in on this particular issue. Mr. Osigwe, thank you for coming on the program.
Thank you for having me.
One of the reasons why we got here in the Edo politics is issues of litigation, and litigation after litigation has gotten us to this particular point. So my natural question will be, what's your first impression of what's playing out in Edo State?
Well, I have not been up to speed with what happened in Edo State, but if I'm to speak generally, it is the resort of politicians to impeachment where there's a disagreement. That's why where a governor wants to remove a deputy governor. And oftentimes, the issue appears not to revolve around whether there's been a breach of constitutional provision by the deputy governor or the person in question, or there's any issue of gross misconduct by the person, or a strong arm use of impeachment to remove usually a deputy governor no longer wanted by the governor, and then the governor would appear to willingly go all out to remove such a person. Maybe that would appear to be what's happening in Edo. That's my impression of it, by the way, because I didn't really see any serious allegation, any serious malfeasance involved in that case, and that would appear to be what the court has considered in arriving at its decision. There was no really serious issue of misconduct involved in the allegation against the deputy governor. But then that remains for the appellate courts to decide if indeed there's an appeal against that decision.
Yes, exactly. So for the sake of the audience who may not be familiar with legalese, so it got a judgment yesterday. The state government has appealed that judgment and even filed for a stay of execution. So what is in law, what is the status of Philip Shaibu as we speak?
Well, if a court has ordered that a person be reinstated, depends on the nature of the relief. If they're declaratory, they can be stayed. But if there's something that the court has ordered to be done or not to be done, and a party files an appeal together with a motion for stay, the parties would stay action or not do anything to enforce that judgment pending the determination of the motion and or the appeal to the appellate courts. So stay of execution simply means do not give effect to this judgment. Court to restrain this other person from enforcing the benefits of the judgment until we have exhausted our appeal or until you have heard our motion. Then practically in law, the moment that motion is filed, even though it has not been heard, parties are expected not to take any step until that motion, which is now filed in court, is heard. So that appear to be the argument of the media assistant to the Edo State governor, saying that, look, we have filed an appeal and filed a motion for stay. Nobody should take any step to enforce it. Police and other persons are requested not to take any step that would impugn that appeal to the Court of Appeal and the pending application for stay.
There's another question being on my mind I must get across to you, and it has to do with our electoral jurisprudence at the end of the day, which has been tested severally, and that has to do with conflicting court judgments. It's sometimes even from appellate court. I would like you to speak to it as well, because there was even an issue in Abuja where, on the same case, court of coordinate or concurrent jurisdiction within the same building, one upstairs, one downstairs, gave conflicting orders. And I remember recently the CJN had to summon a few judges to that effect, literally reprimanding them for what happened. So why is this such a practice in your view?
Well, so many factors and parties are involved. People who go to court to ask for orders in a matter they know is already pending in court, and the court in some cases may be misled into making an order which will be in direct conflict with an earlier order made by another court, and where a party suppresses facts without telling the court that the party is already in court, or on a similar subject matter involving some or all the parties before another court, and the court has made an order. And so they go to the court and get an order. And then sometimes too, the courts themselves share in the blame, because some of these issues the courts ought to be circumspect, especially when the orders are being granted ex parte. I mean, in cases where the ex parte order would appear to be in a political dispute, and where the court should try to find out or hear from both parties what the real issues are before making an order. And then again, sometimes some of these orders were made are widely publicized. So you sometimes wonder whether the judge is making the conflicting orders, meaning the second order may not have heard or read about the order in which case the court ought to have asked the party to address it as to whether the same or the order the court is being invited to make will not be in conflict with an earlier order made by a same court of concurrent jurisdiction, and like he said, is in the same building. So I think that some of these things continue to happen because there are no consequences for bad behavior, either by the lawyers involved or by the judges who make such orders in circumstances that are questionable, or by the parties themselves who mislead the court into making or leading the court in such an embarrassing situation. Right. So we must put in place real enforcement mechanism to ensure that neither lawyers, nor litigants, nor judges find themselves in such situation. And when a person makes such a mistake, which he or she ought to make, that there be disciplinary action meted against such a person to forestall this embarrassment to the judiciary, which does not augur well for anybody.
All right, Senior Advocate, I'm happy you mentioned, because we can't absolve lawyers and the members of the bar from this. I think I understand the election of the Nigerian Bar Association is coming. I think you're one of the contenders for that office of president. So it's important we speak to the issue of the bar. Do you think it's a bit of a recklessness on the side of the bar, knowing fully well that a court has given this particular order or a judgment and still forwards it to and go to another court to get maybe another judgment or something, forum shopping? And how is the bar going to resolve this so that it's embarrassing to our jurisprudence? Don't you think so?
So what usually happens is that people who are involved in this are usually smart. So if they are going to get an order that is in conflict with an earlier order, they change counsel. They bring in a lawyer who can always claim that he was not aware of the other matter, or that the other order made by an earlier court was not a counsel in it, and they use different parties. But everybody knows that the orders or the substance of the case relate to the same subject matter, and usually people work in tandem. No, let me get my own order, even though it be in conflict. Or where there's a clear case or established that the counsel knew or ought to know that an earlier order had been made and ought not to have misled the court into making such an order, disciplinary action ought to be taken. But unfortunately, disciplinary actions are a bit slow. There's need to amend the Legal Practitioners Act and the rules, the rules governing the disciplinary process at the bar, to bring it in sync with modern realities, to make it easier for appeals for disciplinary cases to be determined, and also make it easy for people to petition and have their matters heard. The current system where the matters are heard in Abuja, all disciplinary issues are heard in Abuja, and where the NBA does not play any role, has, in my opinion, weakened the disciplinary process and created a wrong perception that it is very difficult to discipline lawyers. This is an issue we ought to take seriously because it creates a bad image of the legal profession, and it creates an impression that people can get away with anything or do anything and nothing will happen to them. And I think all of us stakeholders should be worried about this and should take decisive action to see that this state of affairs does not continue. All right,
Mr. Afam Osigwe, Senior Advocate of Nigeria, I must thank you, because we needed to bring you to bring this legal pass, because at the end of the day, everything emanated from the polling unit and then went to court, and then we're back to all of this. And I'm sure that given the fact that the NBA is having elections and you're running, some of these things will be part of the things some of you will address. I must thank you. Thank you so much for coming on the program. Thank you, sir.
Thank you so very much for having me. And I hope we'll be able to address some of these issues. Some will require amendment to our law, some will require a change of attitude, but some require collaborative efforts between the NBA body of benchers and the judiciary. But what we all have to work in our best interest to ensure that these things do not continue. And it's not for one man to do. All hands have to be on deck, and we must have to admit that they pose serious threat to all of us. Thank you so very much for having me.
All right, Mr. Osigwe, thank you so much.